Hello and welcome to Runkle the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that, in my view, is really exciting. It's the case of the Queen and Fehr. I don't think this case has gotten a whole lot of notice. I almost missed it. I caught it because somebody on the Discord said, hey, you should do a news roundup. And there was a news article about this story in sort of a feel-good kind of fashion. They didn't seem to really understand how big of a deal this case potentially is. But initially I thought that this news article must be wrong because what it was describing went against the previously established jurisprudence. I pulled up the case because I figured I might be able to do something pointing out how the media got it wrong once again. They got it right. This is actually a really exciting case. Let's have a look at it and I'll try to explain why it's such a big deal. This is the case of the Queen and Fehr out of British Columbia. So we see it's out of Kamloops and was heard October 17th and 18th, and the decision came down December 2nd. So fairly recent, of 2019. Let's have a look at what's going on here. Terence Scott Fehr is a community-minded and law-abiding citizen. 20 years ago, however, in a time of financial need when he was a very young man, he made a terrible decision. He decided to rob a gas station. In the course of the robbery, he suddenly realized that he could not do it. He returned a wallet with cash in it to the gas station attendant and ran out of the station. Mr. Fehr was arrested almost immediately. After giving a full confession, he was released on a promise to appear. 38 days later, he entered a guilty plea. That's real fast. That's probably his first appearance. The sentencing judge accepted Mr. Fehr's expression of remorse and sentenced him to a 1-year conditional sentence order with 3 months of house arrest and significant community service work hours. As mandated by Section 109 of the Criminal Code, the sentencing judge also prohibited Mr. Fehr from possessing any prohibited firearm, restricted firearm, prohibited weapon, prohibited device, and prohibited ammunition for life. So let's have a look here at what exactly that means in terms of what's going on here, because there's a bit to unpack here. So he's sentenced to a conditional sentence order. This is nominally a jail sentence. It's counted as a jail sentence, but it's jail that's served in the community. It usually includes a period of full house arrest, often stepping down to a curfew, and then maybe stepping down to something more akin to a probation order. However, the reason why it's noted as being a jail sentence in the community is that if you screw up on a conditional sentence order, the court has the power to direct that your CSO be collapsed. And what that means is that whatever remaining time is on it turns into actual jail. If you are, 3 days into a conditional sentence order and it says, you're to be on house arrest and the police find you outside of your house and you're not sort of within exceptions or the house wasn't on fire so it's not an emergency, something like that, the judge who sentences you for that breach can say, well, you're doing the rest of the time in jail. So they have some teeth to them, but they are obviously less unpleasant than actually spending the time in, a small 8x8 cell. We see here that this is an individual who's getting a conditional sentence order for a robbery, which is uncommon, and is probably because of the very unique facts. This is a very unusual circumstance. However, he's running up against Section 109 of the Criminal Code. Flip over to that. 109 tells us mandatory prohibition order. Where a person is convicted or discharged under Section 730, I'll cover that in another video, of an indictable offense in the commission of which violence against a person was used, threatened, or attempted, and for which the person may be sentenced to imprisonment for 10 years or more. That's what's catching this one. Robbery is a crime that either involves use of violence or threats of violence, and you could be sentenced on a robbery for 10 years or more, even though he hasn't been here. So scrolling down a little bit further here, we see that the court that sentences the person or directs that the person be discharged, as the case may be, shall, which means must. The judge has no discretion here. They can't decide to do otherwise. In addition to any other punishment that may be imposed for that offense, or any other condition prescribed in the order of discharge, make an order prohibiting the person possessing any firearm, crossbow, etc., 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 during the period specified in the order, which they provide some guidance for. So on a first offense, any firearm other than a prohibited firearm or restricted firearm, and any crossbow, restricted weapon, ammunition, and explosive substance. So that category, they must put in an order that starts on the day the order is made and ends not earlier than 10 years after the person's release from imprisonment after conviction for the offense, or if the person is then or is not imprisoned or subject to imprisonment after the person's conviction from or discharge from the offense. So in the case of Mr. Fehr, because that 1-year conditional sentence order counts as imprisonment, it would have been 11 years later that this part expires. But note that this is anything other than prohibited firearms, restricted firearms, which are covered under the next section, because those you'd be banned from for life. So any prohibited firearm, restricted firearm, prohibited weapon, prohibited device, and prohibited ammunition. Life term for that, no discretion, nothing. So why is that a problem for Mr. Fehr? Let's jump back to the case here. So we see, since that low point in his life, Mr. Fehr has led an exceptionally pro-social life. He's married and has 3 children. Though he became a journeyman electrician, he followed his heart to make a tangible difference in people's lives as a pastor and active community volunteer. By letter dated August 29, 2008, Mr. Fehr received a pardon from the National Parole Board. In its letter, the National Parole Board wrote in part as follows: "A pardon is evidence of the fact that a conviction should no longer reflect adversely on that person's character and removes any disqualification to which the individual is subjected." There's going to be a big asterisk on that. This signifies the intent of Parliament that a person to whom a pardon has been awarded under the Criminal Records Act should no longer be made to suffer any legal disabilities or penalties imposed as a result of a conviction. However, a pardon does not erase the fact that an individual is convicted of an offense and has a criminal record, or affect any prohibition order imposed under the Criminal Code of Canada. Skipping down a little bit, they note that this accurately reflects Section 5 of the Criminal Records Act, which provides that removes any disqualification to which the person so convicted is by reason of the conviction subject by virtue of the provisions of any Act of Parliament other than Section 109, 110, 161, or 259 of the Criminal Code, or other provisions of the National Defence Act, or of a regulation made under an Act of Parliament. Remember, we were just talking about Section 109 of the Criminal Code. So a pardon, which they've now been renamed to record suspensions, does not cancel your firearm prohibition if you got one under Section 109 or 110. This is a big problem because Mr. Fehr now aspires to become a police officer. On the basis of everything I've read about Mr. Fehr, I have no doubt that he's the kind of person who would fulfill that role admirably. The trouble is that in March 2019, the RCMP informed Mr. Fehr that his application to join the force could not proceed because his pardon did not cancel his lifetime firearms prohibition. Because his lifetime firearms prohibition was mandatory, and perhaps because he's already been pardoned, Mr. Fehr cannot appeal the imposition of the lifetime firearms prohibition imposed by the sentencing judge. Also, because it's now been 20 years. You typically can't appeal something 20 years after the fact. That's just, there's time limits on appeal. This is a bit of a big deal for him because there's provisions in the criminal code that allow you to vary it, but they're somewhat limited. And let's have a brief look at that. Actually, it's in the case here, so I'll just rely on the case rather than jumping over to the criminal code. So because Section 113 of the Criminal Code only allows a prohibition order to be lifted for sustenance purposes, or where the prohibition would constitute a virtual prohibition against employment in the only vocation open to the person seeking to have the prohibition order lifted, Mr. Fehr is unable to apply under that section to have his lifetime firearms prohibition vacated. What Section 113 does is it allows for carving certain exceptions into the prohibition. So you're actually still under a firearm prohibition, but it sort of cuts a hole into it to allow you potentially to hunt for sustenance purposes or to work in certain fields. Let's have a quick look at that here. So lifting of prohibition order for sustenance or employment, you can see that it's actually very restrictive because you have to establish that you need a firearm or restricted weapon to hunt or trap in order to sustain the person or the person's family, or that it would constitute a virtual prohibition against employment in the only vocation open to the person. That's a tough test. And where you've got an individual like Mr. Fehr, who was clearly working already, saying that it's the only vocation open to them is going to be a tough sell. Because why not just stay with the job you're with currently? So this is a really narrow restriction. And the effect of the order is just that it allows for a license or registration certificate to be issued, and that it can be issued only for sustenance or employment purposes, and they can have terms and conditions. So for instance, you can have people who have the permission then to have a firearm for hunting purposes, but there might be conditions like they can't even keep it at their house, and so they have to go pick it up at a friend's place in order to go hunting and then return it afterwards. They're very restrictive sorts of exceptions. But Mr. Fehr is applying to be a police officer. The police don't care if there's exceptions there, even if those exceptions would allow him to do the job. Because he's under a prohibition order, they're not going to take him. So he needs to have this prohibition order vacated entirely. That's a big deal because previously this was not possible. And when I say it's not possible, there was actually a decision, and I'm not going to go through that one in detail here, but it's a decision from earlier that same year, January of that same year, that actually said that it was impossible, that the court does not have jurisdiction to do so. Let's continue. Because the Supreme Court of Canada has previously ruled in the Queen and Wiles that mandatory firearm prohibitions do not infringe Section 12 of the Charter, Mr. Fehr has poor prospects of mounting a successful constitutional challenge to Section 109 of the Criminal Code. As a result, Mr. Fehr has taken the only realistic step available to him. He's applied to have the court exercise its inherent jurisdiction to vacate his lifetime firearm prohibition. Now, what he's basically saying there is that he wants the court to cancel this because he's saying you have the power because you are a court. And as mentioned, this same argument was made as early as January, sorry, I was wrong about January. It's March and April of the same year of 2019. In the case of the Queen and Williams out of British Columbia, that same argument was made and the court found that it did not have the inherent jurisdiction to vacate the lifetime firearm prohibition. And this is in keeping with the case law beforehand, which essentially said that the court couldn't do anything about these. So let's have a further look here. The Crown is supportive of Mr. Fehr's application. Specifically, the Crown agrees that the court has the inherent jurisdiction to vacate Mr. Fehr's lifetime firearms prohibition and that the court should exercise its inherent jurisdiction in favor of Mr. Fehr in the circumstances of his case. So the Crown is on side because this guy sounds like a stand-up dude. He sounds like a solid guy, and everybody thinks he should be able to become a police officer. But we've got this roadblock. So that's why this was a 2-day hearing, even though the Crown is in agreement, is it was going to be both sides trying to convince the court to actually go ahead and do this. So they talk here about, in the Queen and Karen, the court is reviewing the inherent jurisdiction of the Alberta Court of Queen's Bench. Now this was in terms of making a costs order, so they're ordering people pay money. But they're saying there's a bunch of principles here. Inherent jurisdiction of a provincial superior court is broadly defined as a residual source of powers which the court may draw upon as necessary whenever it is just or equitable to do so. These powers are not derived from any statute or rule of law, but rather from the very nature of the court as a superior court of law. Novelty is not a barrier to necessary action. So because nobody else had succeeded at this before, that doesn't mean that it's necessarily a barrier here. The inherent jurisdiction of the court is wide and may be invoked in an apparently inexhaustible variety of circumstances, and a categories approach is not appropriate, and the breadth of the court's inherent jurisdiction requires that it be exercised sparingly and with caution. What they're talking about here is sort of the essential unwritten powers of the court, and they're saying that they have to be exercised sort of minimally because it's the court essentially granting itself power. That's a dangerous thing. But let's continue. One limit on the exercise of the court's inherent jurisdiction is that the court may not contravene an express statutory enactment. In his widely cited paper, The Inherent Jurisdiction of the Court, I.H. Jacob wrote, "The general jurisdiction of the High Court as a superior court of record is, broadly speaking, unrestricted and unlimited in all manners of substantive law, both civil and criminal, except insofar as that had been taken away in unequivocal terms by statutory enactment." So there's some further discussion of this. There's a case where they concluded that they had the inherent jurisdiction to fill an unforeseen gap in the criminal code to prevent an injustice by varying an intermittent sentence. So to prevent an injustice. And they note that they concluded that he had the inherent jurisdiction to supplement the legislation to extend the detention of things seized in the course of a police investigation, because to do so would, or to do otherwise would lead to an absurdity in that either the investigation would be jeopardized or participants in the investigation would be endangered. Now, at this point, I want to jump over to a provision. This is not a firearms provision. This is actually a provision of the sex offender registry. So if you get a sex offender order, that order might be for life. But there's a provision here, application for termination order. A person who's subject to an order, again, sex offender registry order, under certain subsections, you can apply to terminate that after 5 years. Under other subsections, 10 years, or some other subsections, 20 years. So that's a waiting period before you can say, please cancel the sex offender registry order. And that's an application to the court. The court can say no, but you have to show why the court should do so. But there's this other little provision here, and that is pardon or record suspension. So despite those time limits, if you get a pardon or record suspension, you can apply for a termination order. Again, sex offender registry, but not, there is no provision like this in the criminal code for if you get a firearms prohibition. So I've seen people who have made mistakes early in their life, often, as a 19-year-old, they dealt some drugs or they got into some sort of violent altercation, and then they're stuck with these lifetime prohibition orders. And they're going, how do I get that changed? Previously, the answer was, you can't. Now, if you were under a sex offender registration order, I could help you out here, but not because, not when you're under a SOIR order or a sex offender, not when you're under a firearm prohibition. That's a little bit of a strange circumstance, right? So in the circumstance of this case, I am satisfied that I have the jurisdiction to supplement the legislation to prevent an injustice and avoid an absurdity. In particular, I am satisfied that the absence of any provision to lift a lifetime firearms prohibition in Mr. Fehr's circumstances is an unintentional gap in the legislation that leads to at least two absurdities. First of all, lifetime firearms prohibitions are intended to enhance public safety. In the circumstances of Mr. Fehr's case, however, refusing to lift the firearms ban will not meet this objective. In fact, it is a lifting of the ban that has the potential to enhance public safety by allowing Mr. Fehr to pursue his application to become a police officer. Secondly, pardons are intended to remove disqualifications that adversely affect people like Mr. Fehr, who've turned their lives around and received pardons. Only a lifting of the ban will completely fulfill the intention of the legislation with respect to Mr. Fehr. In coming to my conclusion, I note that three very substantial protections remain in place. One, regardless of the status of any firearm prohibition, the criminal code already prohibits citizens from possessing prohibited weapons, prohibited firearms, weapons, devices, and ammunition. Two, the court will exercise its inherent jurisdiction to lift a mandatory firearms prohibition sparingly, with caution, and only in the clearest and most compelling circumstances. And three, even where a mandatory firearm prohibition has been lifted, the possession of restricted weapons will remain highly regulated and controlled. Fair enough. Those things are, he's saying we're not going to do this often, and there's already tight gun regulations, so the public is not endangered here. Having reached the conclusion that I have the inherent jurisdiction to vacate the mandatory lifetime firearms prohibition made under Section 109 of the Criminal Code, I have no hesitation in exercising my inherent jurisdiction in favor of Mr. Fehr. He's a person who made one terrible mistake many years ago, but has since led an exemplary life. And when we think about the terrible mistake, he goes back and turns in the wallet again. That's very unusual. There's no doubt in my mind that vacating Mr. Fehr's lifetime firearms prohibition will not jeopardize public safety. In fact, in my view, there's a very good chance it will enhance public safety. Furthermore, vacating Mr. Fehr's lifetime firearms prohibition will fulfill one of the main goals of the CRA by removing a barrier that is preventing Mr. Fehr from pursuing his dream of becoming a police officer and from fully realizing his potential to contribute to his community. For all of these reasons, I vacate the mandatory Section 109 firearms prohibition imposed on Mr. Fehr on May 18th, 1999. This is a huge deal because previously this was completely impossible. I've had people come and say, hey, I got this firearm prohibition ages ago, and the only answer I could give them is, sorry, you're out of luck. This case opens the possibility that other people in fairly unique circumstances, like Mr. Fehr's, but I've seen a lot of these kinds of unique circumstances. 20 years is a lot of time for someone to turn their life around and to really experience a lot of growth and change. So somebody who might have been an absolute terrible person at age 19, at age 50, they might not be, a bad person. They might be, in fact, very pro-social. This is huge. This is a potential game changer. Now, the question is going to be whether other courts in other jurisdictions and higher levels of court will accept this reasoning, or whether Parliament will look at this and say, now is the time to fix this situation people can be in where they can have a firearm prohibition with no means of reviewing it. That was a big injustice, where you had people who were banned from having firearms, but who didn't have any real means of reviewing it except for that narrow exception carving aspect of Section 113. This is huge. I hope it's followed by other jurisdictions. I hope perhaps Parliament looks at this case and says, yes, in circumstances like this, there should be a legislated path open for somebody to, to get this changed. Perhaps something that says, when you get a record suspension, then you can apply to have this changed, akin to what we've got on the sex offender registry. Again, it's really bizarre that it's harder to get off a firearms prohibition than it is to get off the sex offender registry. It makes no sense. And as I said, I've seen lots of circumstances where people have completely turned their lives around. If we believe in rehabilitation, if we believe that people can change, that they shouldn't necessarily be defined by their past actions, however bad those past actions might be, and this is reflected in the pardon and record suspension system, there should be a path to regaining your full sort of status, especially because, as we can see here, these bans have substantial effect. So, as I said, this is a case that I think is a really big deal. It's a real sleeper of a case. I don't think anyone has really taken note of how big this could be. Now you guys know, which puts you ahead of, I think, most people in Canada. This is a really big deal. So once again, thank you for watching. I hope you guys are as excited about this case as I am. Please like, share, and subscribe. I also want to thank my $10 Patreon supporters. A list will be following immediately after this. And once again, I hope this has armed you with knowledge. Thank you.